So when we get to, um, thank you. This is the February 20th, 2024 meeting of the
Blue
Planning
book.
Commission.
What it says.
So Fred, I think you're unmuted.
Yes,
Yeah.
I muted it.
So, call the meeting to order at 7:03. First item on the agenda is to review the agenda for any additions, removals, adjustments. I have nothing. Does anybody else have anything they want to consider? Hearing nothing, we'll keep the agenda the way it is. Next thing is public comment. Do we have any public comment? I think our only public left. Okay.
Okay, thanks.
So we'll move on to item 3, new business. I have asked Kevin Brown to come in and give us an overview discussion about the enabling statutes for zoning, which he's very graciously come in tonight to do that. Kevin Brown, for those who may or may not know, is the chair of the DRB and also town attorney, right?
Right.
So I think the proper thing to do is, I don't know who knows who, but maybe we could just go around. Starting, you can't see the screen, but I'll ask you to introduce yourself. Let's start with Slim.
I see Slim, yep.
And
And there's
then
Fred.
Fred.
yep,
John,
Fred Baser.
John. Nope, John,
Melissa, I don't know.
and then Melissa Hernandez, who actually has the store on the corner, the recycled reading store.
Okay,
So she is on there, and then Shannon, you've met her.
Shannon?
And then I'm Kevin, I'm the other
Yeah,
Kevin.
right,
So with that, I'll just let you
sure. So,
start.
good evening, folks. I'm here as, I guess I'm here with my second hat tonight, which is town attorney. I've been practicing in private practice for, this is year 34. Have several areas of specialty, one of which is municipal law. And so I have a long history with zoning in various types of towns that are small and have relatively rudimentary zoning, towns that are larger and actually have no zoning. Yep, they're still out there. Towns that are pretty developed in their zoning approach. So these are lay boards, and so sometimes people who choose to serve, which is in short supply, unfortunately, might not have the sort of the background that's helpful to understand your role. So I had actually met with the select board earlier in the year to describe for them how zoning works and what the limitations and parameters are, because the select board and the PC are both involved in developing new bylaws. So that's why Kevin asked, he was there for that, so he asked me to come in here and basically give that same overview. So in Vermont, we follow the minority rule about municipalities, which means that a municipality exists as a creature of state law. It's a creation of the state legislature, and a town or municipality has only that power that the legislature expressly gives it, or any necessarily implied powers. That there are several states that follow that rule. That's what Vermont has always followed. It's called Dillon's rule. It's the minority position. The majority position is what's called home rule. And in a home rule state, which we are not, a municipality has all the power that the state government would have, unless the state or the federal government has taken some power back. So we're not a home rule state. We're a Dillon's rule state, which means we have to find, in municipal law, if we're looking at regulatory authority, we have to find a grant of power from the legislature, and then a town can go implement through regulation that power and any necessarily implied power. So The select board is what's called the legislative body. So they're kind of like at the municipal level, they're like the state legislature, the General Assembly. They actually can pass law. And there are two basic kinds. One is a regulation or ordinance. A lot of these terms are used interchangeably, but there's a statute in Title 24, 2291, which lists 29, it's up to 29 specific types of regulations that a town can adopt. But that's an adoption by the select board, which is a pretty simple process, happens at public hearing. The other kind of regulatory animal is called a bylaw. And that's what's you folks are dealing with in the Chapter 117 Municipal Planning and Development Act. That's the big statute. It's over 100 pages long that the Planning Commission, the DRBs live in. And the difference between a bylaw and a regulation is how it's adopted. As I said earlier, just an ordinance or regulation is just passed by the select board in open meeting. It's on the agenda. There's no necessary public hearings. It's just done in open meeting. They can have multiple hearings, or they can just do it once, as long as there's notice. A bylaw is what you folks are dealing with in developing changes. A bylaw like such as zoning or flood hazard or shoreland, they originate in the Planning Commission. The Planning Commission has hearings, sometimes multiple hearings, and ultimately comes up with a draft, a proposal. That proposal is sent on to the select board. The select board then has hearings or multiple hearings and decides whether or not to change or accept the Planning Commission's recommendation. And then ultimately the bylaw is adopted. In Bristol, we adopt our bylaws by town vote. And there's sort of a pocket veto in the procedures that if the bylaw is finalized, select board has it for a year and doesn't act on it, then it's deemed denied. So the Planning Commission has two major responsibilities. One is to develop the municipal plan, and the other is to help develop bylaws. The purpose of zoning is to implement, at least partially, the town plan. The town plan's a goal. It's the future objective to which the bylaws are supposed to be working toward. The zoning regulations can be a partial implementation. The town plan itself is not regulatory. It's a goal. It's a planning tool. So there are 3 statutes in Chapter 117 that set out in sort of different ways what the zoning powers are. There's a 4412 is the statute that lays out various things that are out of bounds in town bylaws. And so bylaws can't prohibit equal housing. They can't prohibit mobile homes. They can't prohibit mobile home parks. It's sort of a laundry list of items that are off base. They can be regulated, but they can't in some ways, but they can't be basically excluded. Accessory dwellings, which you have worked on, that's one of the areas that has to be allowed. Residential care homes, existing small lots, home occupations, childcare homes, and non-conforming uses or structures have to be addressed in the bylaws in some way. How are we going to deal with changes? How are we going to deal with a change in use or structure when it's a non-conforming structure? So that's something that was fully compliant with all regulations. And then there was a change in the regulations or an adoption of regulations, which made that use or structure non-compliant. So there's a statute that tells us how the town has to deal with that. There's some flexibility there, but it has to be dealt with. 4413, these are all in Title 24 and part of the Chapter 117 Municipal Development Act, or Planning and Development Act, sorry. There are certain things that are pretty hard limitations, state institutions and facilities. There can be regulations, but there can't be regulation to the extent that it interferes with the intended use. State buildings, public and private schools, churches, hospitals, solid waste, hazardous waste, public utilities, agricultural practices, silvicultural practices, which is forestry. Those are the main ones. And then there's a big statute, much larger, called numbered 4414, and that sets out the various permissible types of regulations that zoning or planning bylaws can handle. Zoning districts, town centers, growth districts, design guidelines, compact settlements, housing types, street layout, natural features and open space, agricultural, rural, forest, recreational, shorelands, design review districts, historic districts, overlay districts, conditional use, performance standards, waivers, archaeological resources, wireless, there's others. Those are not required, but they're appropriate subjects for regulations in bylaws, zoning, or other types. So the Vermont Supreme Court has said on many times, in many cases, that zoning is in derogation of private property rights, meaning it constricts or inhibits, restricts, limits private property rights, and therefore, which are constitutionally protected, and therefore any ambiguous, well, let me back up. Therefore, when the court or the DRB is called upon to interpret a bylaw, a regulation, the directive is that the bylaw must be strictly construed against the municipality and in favor of the property owner. A corollary to that is if a term is ambiguous, meaning it's susceptible to more than one reasonable interpretation, and lots of terms are, then when you're interpreting a bylaw, zoning or otherwise, then the decision-making body, DRB or the court, environmental court, has to apply the meaning that is most favorable to the property owner. So, and that presents a challenge for the PC and the select board when ultimately adopting regulations that puts a heavy thumb on the scale of needing to have pretty well defined terms. It's not always possible, but as much guidance in the terminology as possible, because if it's an elastic term, a term that could apply narrowly or broadly, the property owner gets the benefit of the interpretation. The interpretation is given to the property owner that benefits the property owner. That's what I've got. Any questions? Hope that wasn't too much, but that's the backdrop against what you good folks are doing undertaking your task to revise or consider revisions to zoning bylaws. It's a really important step. And well, one more thing. The other thing you have Vermont Supreme Court has been pretty strict about is beware of standardless delegations of authority to either the zoning administrator or some review committee. If there's no standards in the bylaws to guide the application of the bylaw to the set of facts, then it's considered an improper delegation of legislative authority, and the regulation will fall. I guess the most obvious example that has developed in recent years is towns can have waiver authority built into the bylaws for the zoning administrator to waive certain take a minor change and make that decision administratively, rather than say it's on conditional use or something like that, rather than having to go back to the whole board. But the bylaw itself that grants that waiver authority has to have some standards in it to guide the zoning administrator in their decision making. Because if it's just wide open that says it's up to the zoning administrator to determine whether it's major or minor and can be done administratively, then it's a standardless delegation, which is an abuse of the improper delegation of the legislative authority given to the it's actually the regulatory authority given to the zoning administrator. So that's very important too. When there's it's important to have at least standards in there to help guide the decision maker if the decision maker is given some discretionary power to do something. So the DRB has discretionary power under, say, conditional use. And that comes directly to us. The zoning administrator doesn't rule on conditional use. It starts with the DRB or the ZBA if it's a town with a zoning board. But there's a pretty elaborate statute in chapter 117 on conditional use that lays out several general standards and then several site-specific standards. And they don't tell you the result. It's always being applied to the particular case, but it gives a pretty good roadmap of issues to consider. And so if you are creating a bylaw that is delegating authority to a decision maker, it's important to give as much guidance as you can for what factors to consider to avoid a successful legal challenge down the road.
John has his hand up.
Go ahead, John.
Thanks. A couple things. I don't know if this is going to be a question or more of a statement, but let's see where it goes. I just want to go back to your comments, Kevin, about zoning. Sort of the default is sort of to err on the side of the property, the applicant, the person who has property rights they want to develop, right? I get that comes from the august Vermont Supreme Court, and I give it all due respect. But I would point out that our documents in Bristol, I don't know about other towns or other states or what have you, but I know in Bristol, both the town plan and the zoning regulations talk about the importance of, at least the town plan does, of balancing the rights. Because in my mind, and I think in the mind of whoever drafted the prior town plan and zoning regulations, that it's not just about the rights of the developer, the erstwhile developer, the person applying, that the mission of the zoning board and the town's interest is protecting the established uses in a zone where certain uses are allowed and others are not. And if somebody proposes something that offends the uses or somehow degrades the uses in the zone, then that's something for the board to take into consideration, is it not?
Yes, I didn't say anything to the contrary.
No, you didn't really, but you did say that the law, according to the Supreme Court, it sort of weights the interests of the applying party. You made no mention of the...
No, I didn't say that, John. What I said was that when there's an interpretation of a bylaw, zoning or otherwise, and the DRB as a quasi-judicial body or the environmental court is called upon to construe the bylaw, it's construed strictly against the town as a matter of law and in favor of the property owner. And the corollary to that is if a term is ambiguous, and not all terms are, but some terms are, the property owner gets the benefit of the interpretation that favors them. That's all.
I heard that, but you also said that zoning as a fundamental proposition abrogates the applicant's property rights. And that's true. I agree with that. But I would add that the failure of zoning, or the lack of zoning, or the unenforcement of zoning, if you have it, offers the opportunity to abrogate the existing use and the rights of people who are already in that location. Is that right?
I don't.
If an applicant proposes something that's not appropriate for a zone, and the zoning board says
Then
no.
the bylaw gets enforced.
But if it becomes ambiguous, like it just seems like in less clear circumstances, which there are many in zoning, I think, people use different terms, they confuse terms, it's complex, there's ambiguities that happen and are litigated, right? I hope that the Vermont Supreme Court can keep in mind that the interests at stake are not only of the person proposing to develop the property, but they're interested in the existing uses, perhaps the next door neighbors to that property. And
Of course,
I hope the law
of course that's true. Of course that's true. You're taking two rules of construction that I've articulated that are black letter law and extending that to mean zoning is designed only to help property owners and not take care of neighbors at all. Of course it's not.
That's not really what I'm saying. I think I'm just saying, I guess I'm focusing on your statement that zoning abrogates or potentially abrogates the property rights of the developer, of the applicant. That's true. I'm agreeing with that, but but the application of zoning is equally about protecting the established property rights of the neighbors, right?
Well, no, in this sense, if you're thinking that a neighbor's own property rights have property rights over what their neighbor does.
Well, they do. They have the right not to have excessive noise, for example. They have the right to not have excessive air pollution or
Without
lighting.
zoning, without zoning, you've got the common law as far as what would property owners, neighboring property owners, what would they, if you're a neighbor and you're having a problem with your property owner in the absence of zoning, if you have a problem with a neighbor, you've got essentially two main causes of action. One is trespass, and sometimes there have been attempts to have pollution be considered trespass, water, that kind of thing, and nuisance. Those are time-honored common law civil claims that pre-existed zoning go back to England. We got our common law from England. So those things are there as part of judge-made law. So outside of that area, you need either statutes or regulations. And regulation which restricts one owner's property rights is well, I won't repeat myself. It's how those property rights are, how the regulations are interpreted when you have a situation of ambiguity or uncertainty about the scope of a regulation.
No, I understand the law gives the bias to, and I understand some of the reasons why it gives the bias to the proposer of the project if there is ambiguity in the law. I get that. I just want to establish that in my mind, at least one person's mind, that zoning isn't just about the potential to abrogate applicants' property rights. It's also about protecting what the community has decided and chosen and established in its town plan as its vision for itself.
Of
And
course. Did I say something contrary to that?
Well,
No,
sort of.
no,
because
I did not,
it's
John.
really fundamentally about whether we abrogate, what degree we abrogate the
Of
applicant.
course,
Okay, John, I think
Of
we're starting to
course
go in
not.
circles.
Of course
So-
not. The zoning bylaw, the decision-making bodies implement the bylaws. And of course, that means the rules for the zone, they get applied equally in the zone. Of course, all of that's true. I haven't said anything contrary to that.
I'll just conclude with, if we consider the potential abrogation of an applicant's rights as the only standard when we consider a given application or project, or in the planning commission's context, making a rule for our zones, then we're missing half the story. It's not just about the developer and how they get to do it. It's about protecting the established rights and uses in a zone as established by the community and elucidated in the town plan and the zoning regulations.
And I did not say anything contrary to that.
Thank you.
So, anybody else have a question? Shannon, do you have anything?
I do.
Go ahead, Melissa.
Yeah, you mentioned, there was a lot, so I'm trying to,
Sure.
and law
know.
is not my, certainly not my thing. But you mentioned that if a bylaw or a new bylaw or a change is not enacted or acted upon by the select board within a year, then it's considered denied. Is that
Right, it's a,
right?
right, if the
So-
from the time the PC sends the purported final version to the select board
Uh-huh.
for comment, the select board is supposed to act on it within a year.
Okay, and when you say act on, do you mean implement, or do you mean go through their process of public forum and if it is to be voted on by the public for a vote? Is that what you mean, or do you mean?
Yeah, well, it means
Yeah.
both. I mean, if the select board didn't call a hearing,
Yeah,
then the clock's running. If the select board had a bunch of hearings but just didn't take action to send it on, which I've had happen, then it's deemed denied.
so basically we could potentially have done all this work, have public forums, get it voted on. The people say, the citizens say, yes, we agree with this, and the select board can just choose not to act on it. I mean,
No,
implement
no,
it.
well, it's got to get passed. The select board does have to agree with it and then pass it on for adoption. That's what I'm talking about. If it's adopted, then it's adopted. It's adopted.
Okay, so once it's like out there and it's voted on, then
Yeah, it's a done deal.
It is what it is. Okay.
Right, no, it's a
Okay.
done deal. I've only seen or heard of it happening once in all my time. And it involved the town that I represent, which
Yeah.
town of Rutland does not have zoning.
Yeah.
And,
Okay.
there have been various attempts by the PC over the years to present different versions of zoning. And years ago, 10, 15 years ago, one of those versions, there were various hearings, but the select board never got around to acting on it within a year, so it was
Okay.
deemed denied. It's kind of like a pocket veto, and if you remember from civics class, when the
Yeah.
when the law goes to the president for a signature, if he doesn't sign it.
Yeah. He doesn't veto it, but he doesn't sign it, and yeah. Okay.
Pocket veto.
Okay. All right. Yeah, I thought it would have been, if that was the case, it would be unusual because, if they sort of task us with doing this and then
Yeah, no,
don't do anything with it.
it's like I say, it's extremely unusual. I've only seen or heard of it happening once in
Okay.
34 years. Doesn't mean it didn't happen in other towns, but
Right.
most towns have zoning or there are other kinds of bylaws, subdivision. The town of Bristol only recently had subdivision.
Yeah.
The town of Killington has zoning, but not subdivision. So Bristol has both. Bristol was the other way. Town of Rutland has subdivision, but not zoning. So most towns have both, but not all do. All subdivision and zoning regulations, they're all bylaws, meaning they get adopted through the actions of the planning commission and then the select board as the
Select board.
legislative body.
All right. Thank you.
Okay, Slim, do you have anything?
No, I'm good.
Okay, Bill
No, thank you, Kevin.
and Fred?
I'm fine.
Okay, so couple things that at the risk of digging up dirt. When we went through the recent,
Oops, John's gonna say, John, do you have your hand up again?
I do.
Do you want?
yeah, go ahead, John.
Thank you. Kevin, a couple more things, and I don't know, these might be quick answers. I hope so. Could you help us understand what is your understanding of what spot zoning means and what that looks like?
Well, it's easy to say, but sometimes tough to discern, but it's treating a particular property with its own special zone. It's giving specialized treatment to a single property, a spot. And so it's not getting, you don't really have a district there where you're having uniform rules applied to people in the district or the classifications within the district. It's essentially a class of one that got its own rules. If that helps.
Would it include like changing the allowable uses in a zone to that in a way that benefits just one property?
Probably not.
In the groove.
Because because in amendments happen all the time. And if others could take advantage of the amendment, then it probably wouldn't be considered spot zoning. There are a few cases, I couldn't give you a fact pattern off the top of my head, but there are a few cases out there in Vermont as elsewhere, but that's the concept is giving one particular property its own set of rules. And it's improper under the law. What's lying behind the pejorative label spot zoning. That's a death sentence of a label. What's behind it is the equal protection clause, in that like properties should be treated alike, and that's part of what the classifications of zoning do. So if it's a spot zoning type situation, the argument is really it's an unequal application of law, which has a constitutional underpinnings.
Cool, thanks. Another quick one or two before we move on to another agenda item. Are there any towns in Vermont that require site plan review or more stringent review for single family homes?
Not that I know of. I could see it as an abstract question. It's too broad. I can think of zones, say as a conservation district, where single family homes might be a permitted, I'm just making this up. I could see in that kind of a zone, maybe site plan review possible and something like that, or in a historic district. I'm not aware of any. Usually a single family home is a by right use, at least in some zones. There are zones where in some towns where single family home is not a by right use. You don't say it's an industrial zone or something
Right,
like
here
that.
our commercial zone, it doesn't.
Yeah, or and ours in commercial, so they're not they're not permittable by right in every zone. So I guess it's theoretically possible that in a certain zone that is otherwise potentially inhospitable to single family homes, or the single family homes would be contrary to the overall town plan, that there could be site plan review overlay.
That's helpful, but I think what I'm asking is, are there any towns where single family homes all have to go under site plan review?
I've never seen one. I doubt that's true.
And
I mean, there are 250 some towns in Vermont. I don't pretend to know I don't know how many zoning, but 99% of them do, I'll bet, or 98, something like that. I don't know. I've never heard of that or seen.
Is there anything in Vermont statutes that would prevent a town from applying site plan review to all single family homes?
Not that I'm aware of.
Is a permitted use can still be subject to.
There is a statute on site plans, so that and so I don't think there's anything. It'd take me a little bit to find it, but it's in chapter 117. There is a site plan it does have its own statute, and it tells what the parameters are: traffic, pedestrian walkways, that kind of thing. Those are the considerations. But I don't think it says, without looking, I don't think it says anything about site plan in response to particular uses.
All right, there's nothing that says, in essence, town may not subject applications for single-family homes to site plan review. Is that correct or not?
I don't think so. Hold on.
And I don't need the answer right now. If that's something that requires a
No,
little.
no, there's a. Well, 4416. I mean, I gotta make sure it hasn't changed. The legislature mucks around with chapter 117 virtually every session. As a prerequisite to the approval of any use other than 1 and 2 family dwellings, the approval of site plans by the appropriate municipal panel, that's the DRB, may be required. So that's telling me that you can't put site plan review on 1 and 2 family homes.
Interesting. And my last question is, in Bristol, permitted uses can still be subjected to site plan review. Is that correct?
We have some of those. They have an asterisk. Personally, I dislike that approach greatly. I wish you guys would not do it. Because it's very hard to not slip into conditional use review, because our bylaw starts to look at site-specific standards, and there's a potential for mission creep there. It's hard to figure out how to, from my perspective, how to apply site plan considerations to a permitted use.
Well, I mean, it goes like this, doesn't it? Like, so site plan review provides for reviewing lighting and noise, shed, and parking and traffic, maybe, you know, in terms of access to the site, those sorts of things that are light. It's never saying no, but it's asking, how are you going to do this? And is there a way that these things can be done, lighting, for example, or where you put your HVAC noise, that can minimize the impact on your neighbors?
Sure,
Right.
but some of those, if you look at our bylaw, it does more than just make sure that, okay, there's adequate traffic layout, and the things that were site plan's kind of grown under, expanded. Initially, it was traffic flow, sight lines, that kind of thing. Even if some of the things you just mentioned are really not about the site per se, they're about the use on the site and the offsite impacts of those use. And so that's where it starts to get difficult, even under our bylaw, in my mind, because now you're weighing uses which are already, but it's a permit by right. And so there's danger there of how far you go without actually becoming a conditional use review for
Right.
that.
Well, you're never going to say no. You're never going to say no. You're something like, let's just take one example, lighting,
Well,
right?
no, I am going to say no. We are going to say no.
Well, under site plan review, you're not saying you can't do this project.
Yes.
You just did.
We just did on Garfield Street because it was not that's a good example where it was that school or whatever.
Artist Guild.
Yeah, I know, but what was it under the bylaw? It was a school or
A club.
Club. That club was a permitted use, but there was an asterisk for site plan review. And the DRB actually denied the permit, even though for several reasons, one of which was it could not present a proper a compliant site plan, didn't have the parking, just didn't have the parking. And so you can deny it.
Well, that was under conditional use though, right?
No,
That was site plan.
no, it was a permitted by right use subject to site plan review.
Right. For a building that's out of compliance already.
It doesn't matter, John. Even if it was a compliant building, you're missing the point. The point is that site plan review, application under site plan review can be denied. Now, I know because I've heard from other zoning administrators that when the League of Cities and Towns training process happens, one of the things that is apparently said is that you can't deny a use based just on site plan. And that's actually not true. It says too much. And so if you have a site that simply doesn't have the parking required that goes along with the site, you absolutely can deny the site plan, and therefore the use falls.
Okay, it's all really helpful. Thank you very much.
So I think when we talked, and I think you touched on it a little bit, maybe a little bit more, is the difference between dimensional standards for a given plot versus the use of those.
The non-conforming uses and structures.
Or whatever the use may be.
Yeah.
We debated at length when we were going through the ADU
Right.
rationale as to how that becomes a second use on a single family dwelling. So I think
Right.
we,
Either within the dwelling or in a standalone structure.
right, and because it's a separate use, it should be looked at potentially different than the single family dwelling.
You could have its own setbacks. A lot of times, say it's in a garage or an accessory building. An accessory dwelling unit can be in an accessory building. You can have accessory buildings that are not accessory dwelling units. Garages happens all the time. So in the village, the former village, our bylaws have had and still have a lesser setback for the accessory structures. So and that would apply whether or not there's a ADU on the second floor of the garage.
But it would still be functionally one use because an ADU is allowed as part of a single family dwelling. I mean, you don't have.
Yeah, it's the same kind of use. I think that's right.
So from a permitting point of view, do you need to have a permit for the single family dwelling and then a permit for the ADU?
If you're starting from scratch versus changing the use of an existing structure.
That's one option, I guess.
Yeah, yeah, if you had a single family dwelling and you wanted to put an accessory dwelling unit in it, the zoning bylaws have to allow for that. Subject to the standards in the statute, which have the size of it, right? But the statute actually says the town can be more liberal than the statute. The statute sets the floor. So if it's say you've got a garage and you want to put an accessory dwelling unit above it, that's a change of use. And so you would need a permit for that, but it's a by right use. Right.
Except I have to disagree because for quite a while, until a change was made in 2017, 2019, Bristol zoning regulations, it recognized that if you want to put like convert part of your existing house to an ADU, that's fine. It recognized that if you had an existing accessory structure, garage, carriage house, whatever, on the property, and you wanted to convert that to an ADU, that's fine. And state statute has lately, said that's all good. But Bristol zoning regulations have for years dealt with two new uses. An accessory structure is one use, and the ADU is the second use in a new building on a property.
I think I just said
as a different animal, and as a regulatable animal, because of course, something that's two new uses that starts from the ground up that hasn't existed before has, of course, common sense says it has more potential impact on the neighbors. So that some of that language is still in Bristol zoning regulations, and some of it was removed at the prior revision, which actually makes Bristol zoning regulations more confusing and more ambiguous than they were before, because we used to have a section in section 404, the ADU section. There was essentially a second paragraph that said, if you're having an accessory structure plus an ADU, here are the rules to follow. So it totally contemplated that as a different and separate animal. Just because you tack an ADU on it doesn't obviate any other use, right?
You lost me. I mean, it doesn't matter what the zoning regs used to say. It matters what they say now and what the state statute says. So you're free, town is free to regulate. And I don't remember what you're saying specifically. I have all the previous iterations, but I don't recall it that way, but I don't
I think,
try to remember. It doesn't matter. We have our current regulations, and if
I think some of those points that John's referring to were problematic for as far as being able to be forced.
well,
Yeah,
I
I
could-
mean, it was problematic when the section that dealt with this unique animal, 2 new uses, an accessory structure plus a new ADU. When that was removed in the last go around, Chris, you said at one point when it came to Garfield Street, you said I didn't have guidance on where to go on that proposition. And the reason you didn't have guidance is because the section, half of section 404 was removed in the last go around. And that section specifically dealt with this unique animal that is a new built accessory structure plus an ADU, 2 new uses. And it refers to them as uses.
they are.
And so we still have this implication that there's this other animal in the zoning regs now, but without half of section 404, it kind of doesn't make sense. And without 404, that's why Chris didn't have guidance, because when he ran down through this application for an ADU and the guy was proposing a new building that was both an accessory structure and an ADU, that guidance wasn't there. If it had been, it would have said, well, if here's how to proceed. And
Well, That's a, I don't know what Chris would have said before. Not the error was that it was a duplex and an ADU was not allowed, period. That was a mistake. Mistakes happen.
that was only one of the errors. There was multiple errors.
Could be.
Yeah, there's 2, John, and I'm
Okay,
pretty certain we know what they are.
Yeah.
so,
Well, in the context of the discussion, it's very helpful.
So-
It's painful to discuss them, but there were many errors. It was larger than 1,200. It was 1,200 square feet.
so let's get off Garfield Street, that's done. The question that I had raised.
And there are lessons to learn from it that I don't feel like we have examined. And the lesson is singular, which is, what are we going to do when we have a new building that is 2 new uses? And the answer is go back to the past, because before we changed it last time around,
So,
uh,
John, I'm just gonna tell
So,
you,
and
the
the
circumstance,
conversation-
this loophole
John?
was dealt
John,
with.
you're out of order. Let's stop it. The question I had raised is the differentiation of uses and dimensional standards.
Meaning,
The-
you mean
with-
setbacks, or you meaning other kinds of
Dimensional standards, or setbacks,
side.
Or
size and all that kind of stuff.
Yeah, the footprint.
But so then. And then uses, but maybe, and if we. I mean,
I think there's nothing, I think you can differentiate if that's what you're asking. If you wanted to say, well, it's in an accessory structure, it's the second floor of a garage, say, in that situation, because it's a more intensive use, you could have different setbacks in that situation, bigger setbacks if you want it. There's nothing to prevent that, if that's helpful. You just want to be clear, and there's a reasonable, rational basis for that type of differentiation. Or it could be, or it could be accessory structure is an accessory structure with its own setbacks no matter what.
but but then an ADU has to be no more restrictive than
Single family.
the single family home.
Well, it
So
has,
it has-
it has size limits unless the town expands, takes away the size.
So the size,
Size
but
constraints.
as far as dimensional standards are concerned, you can't be any more restrictive than a single family, so you can't, I don't think you could put greater.
It can be if it's more than an ADU though, right?
Well, if
It
it's
can
more
be
than
more
an ADU
restrictive. If it's the state says you can't be more restrictive if it's an ADU, period.
For
What it
setback.
doesn't, what the state does not say, the state does not say you can't be more restrictive if it's an ADU and something else. The state doesn't address that, and therefore we may be more strict than if it's just an ADU. It's two new uses. I see how you're struggling to fold in ADU with accessory structure use so that there's an unregulatable category, which is a new building that's two new uses.
Well,
That's
not
a,
all- not all-
that's a loophole that creates an unregulated type of structure. It's simple. You guys are wrestling very difficult. Like you're going all the way. How are we going to do this? How do we do it? Is we call it two uses and we regulate it differently. We subject it to site plan review, just like we used to.
I don't think we had site plan review
Yeah.
before.
It was
Uh,
subject to conditional use review in the
Yeah, I don't-
earlier regs.
I don't
for
remember.
decades.
Okay.
I do remember because I looked at it very carefully. And if you wanted to propose two new uses in a brand new building, it was subject, you could do that. In fact, it was more liberal than what the state is. You said earlier, Kevin, that we can be more liberal. Well, Bristol's regs, as they were written, used to say, if you have a duplex, like right now, the state says you want to have an ADU, but the main residence is a duplex, you're out of luck. End of conversation. You can't have an ADU. That's pretty restrictive. Bristol's regs now say that, but they used to say,
I know
oh, you have a duplex? Well, if you want to go through conditional use review and see how we can make it fit, you might also be able to have an ADU. That is more permissive than what the state allows now, correct?
All right, well,
So-
did I answer your question?
Yeah, I think so. Close enough.
Yeah, so, we probably have some examples where not all ADUs and separate structures are part of an accessory structure. They're not all of a second floor garage. You can build what used to be called the mother-in-law apartment as just a residential cottage, basically, subject to the size limitations, unless the town were to decide to have more liberal size limitations.
Right. And that's just an ADU though, you're saying, right? Not two uses, right?
Well,
If
there's-
it's just an ADU,
Yeah,
There's-
there are some of those.
So in a single family home situation, the thing I struggle with is all of a sudden you have a accessory dwelling accessory structure that's a barn. It could be a barn.
Mhm.
You could have animals in it. You could have a car in it.
Yep.
You could have a accessory dwelling unit in it.
Mhm.
And we seem to be splitting hairs that all of a sudden those are different uses, even though by statute, they're considered allowable uses for.
no, well,
Yeah.
they're not by statute. The statute is silent on when you have two uses. What it does say that if you take that barn and you convert it to an ADU with no other use, then fine. There's very little the town can do to regulate that. The state statute also says if you take a portion of your existing house or you build an addition onto an existing house and that addition is an ADU or that conversion of part of the existing house is, you call it an ADU, fine, you can do that. What the state is silent about is when you say, I'm going to have a brand new accessory structure and an ADU. That's not the same animal as an ADU. An ADU is just an ADU. It's not an ADU and a garage. It's not an ADU and a workshop. It's not an ADU and whatever. It's an ADU and an accessory, it's just an ADU.
There can be two uses in a structure.
We're talking about a new building that is proposed that has two uses, an accessory structure like a garage or a workshop and an ADU upstairs. That's a different animal and the state statute is silent, which means we can regulate it.
So, yeah, I mean, the answer, my general answer to that would be build the garage a month later, apply for the ADU, because then it's a
Yeah,
pre-existing.
and that is an end run around what zoning is supposed to do, which is protect the existing rights, and especially an HDR type zone where you have dense existing neighborhood type development, village type development. If you want to do an end run around those things and create more Garfield streets, that's the way to do it. But let's not call that zoning. Let's call that getting around an end run.
So there's nothing in the enabling statute for ADU that delineates where it goes. It has to be within a single family dwelling, and it has to comply with the setbacks for a single family dwelling in that zone.
That's fine, but an
Doesn't
ADU,
say-
an accessory
doesn't
structure
say-
is a different animal.
It doesn't say anything about where it goes in there, or if you're building something to put it in. It doesn't say anything about any of that, John.
Well, it says an ADU. It doesn't say if you want to build an ADU in a garage. The state is silent on that. And that is a different animal than just an ADU, whether it's new or conversion. An ADU is just an ADU. The state doesn't say anything you attach an ADU to is only an ADU. Where is that in the statute? That we ignore any other use? Find that in the statute, please.
Fred's good.
Oh, Fred, you got a comment?
I have a question, not a comment. Are the setback rules and construction dimensional rules the same for an accessory building as they are for an accessory dwelling?
Currently,
So if someone's just building a garage, their rules are identical to what it would be if someone is building a small accessory dwelling. I'm
Chris,
kind of searching on my memory, and I
Chris-
kind of thought they were different.
Chris is,
Well, Chris is looking it up, but I don't think it is.
Just, let's find HDR, it'll be, just find.
I don't recall.
ADU.
I don't know
I
if there-
just thought that might be useful.
That's the
to all of
size.
this.
But let's see what let's say HDR say about accessory, as far as setbacks and.
It's accessory, just an accessory building.
Yeah, and
No, it's a
let's
separate paragraph.
Yeah, so for instance, Fred, I'm looking at HDR right now under the current regs. And it has two different standards, setback standards, rear yard and side yard. It's 15 feet for a principal structure and 10 feet for an accessory structure. So if there was an ADU and an accessory structure under the current regs, it would be a 10-foot setback. Then there's also a differentiation as far as principal structure and accessory structure on the square footage cap. So 1,000 square feet for the accessory structure and 5,000 square feet for the principal structure. That's maximum in the HDR. So the current regs do make some differentiation there. And I assume if we look at the other districts, some of them would do so some of the other ones would do so as well.
Okay.
Like, I don't know if it does out and say RA5 without looking.
Is it worth pointing out that dwelling is one of the most intensive besides industrial? Like, that's an intensive use, right? When somebody lives in a space, there's a lot of potential impact, and they're also potentially impacted by what's around them, as opposed to a garage where a car lives. Very little impact coming or going, right?
So, I think we touched upon use versus dimensional standards. So is there any other closing questions for
Not a
Kevin?
question, just a statement. I hope this board is not going towards subsuming two new uses and calling anything we call an ADU and forgetting other uses. I hope we're continuing what historically has been, I think, a wise path for Bristol, differentiating between accessory structures and ADUs as two different things, which is we've always done. And I think we should continue to do.
Okay. So,
That
any
wasn't a
closing
question.
wisdom?
Any Well, if there are any other questions, I'll take my leave. These are not easy, these are difficult questions always. It's pretty clear where the mandates are coming from. Montpelier is towards increasing density and increasing housing stock, and hopefully affordable housing stock. Last year's Act 47, I think it was, is the first inroad. My expectation is there'll be more of the same, and the state, because of the affordable housing is such a problem and the lack of housing stock, that there is going to be I would expect increasing restrictions on a town's ability to regulate in ways that might inhibit the increasing residential uses of properties, at least in certain zones, in the core zones. That's just me reading the legislative tea leaves and looking at what Act 47 was about last year. It was driving at the problem of lack of affordable housing. Fred would have probably the best take on it if you still got a finger on the pulse up in Montpelier, Fred.
Well, I'm also a commissioner on the Vermont Housing Finance Agency, and our
Wow.
mantra is affordable housing. So I know quite a little bit about it. And the problems are multiple. It's not just
Sure.
community zoning, it's environmental stuff. We have a project up in Newport that's going to well for the second time, convent up there, old Catholic school, at the church I was married in, up St. Mary's Star of the Sea. And the extra cost to the taxpayer to jump through hoops that they don't have to jump through, from my perspective, is ridiculous. There are many issues concerning affordable housing, why it's not happening, and what might need to be done in order for the gates to open up a little bit more.
Yeah.
Construction in Vermont and many other parts of the country has slowed to a crawl compared to what I remember growing up as a young man. And most of it's self-imposed, all with the best intentions by members of a community and environmental oriented folks.
Yeah, I just think I agree with everything you said. It's a multifaceted problem. One manifestation from a town's perspective is likely to be increasing limitations on likely to be, who knows, but likely to be increasing limitations on the town's regulatory authority over different types of housing stock.
Yeah, perhaps. You know, I smile at this, I don't want the meeting to go on too long, but I've thought about this often. You know, do we have an affordable housing crisis in Bristol? And I would say maybe not. How many jobs are in Bristol? We have more than enough homes of varying values to support the people working here, their grandparents, their whatevers, especially if you consider the greater area of Lincoln and New Haven and Starksboro.
Yeah.
It's where the more heavily densely populated areas are, where industry and businesses are, where they run into the problem, far more so than in Bristol or in Barton or in Fairfield. You know,
Yeah, I agree. You know, one of the other big pressures on affordable housing is the presence of a college. And so student housing in UVM and St. Mike's to a lesser extent, but Castleton and
Middlebury.
no, what's the other, I can't think of the name of it. The other school,
Lindenville, Johnson.
no, the other school in Burlington that was 2 years, now 4
Champlain.
years, Champlain. You know,
Oh,
so there's not, I know Burlington is trying to get UVM to build more dorms because they don't have enough dorms for all the students. And so there's a lot of students renting what used to be housing stock for families. And so, and Middlebury faces some of that pressure as well. And the presence of a college in the town increases the pressure on affordability just because the students are renting.
Absolutely, absolutely. That's why Middlebury College was the main instigator behind this. I think it's 400 or 500 unit development off of Washington Street,
Right.
with a mixture of affordable housing and workforce type housing. They were the ones that pushed that through. I think it's Summit, the development outfit is Summit, which does an awful lot of this stuff, has picked up the ball and carrying it, and they're developing their financing, which we're a major part of. And I hope something happens there, because they're still going to have to go through some rules and regs in Middlebury.
Yep.
And God knows there'll be people that don't want it for whatever the heck reasons.
Sure.
But you're accurate. And if the state gave UVM a little bit more money, we're at the bottom of the totem pole there, to build dorms, they get built.
Right. No, there's,
But we're cheap, at
Yeah,
least in
yeah.
this front.
yeah,
I would
no,
like to say something, interject if you don't mind.
Go ahead.
We actually do need more affordable housing in Bristol. It is an issue. A lot of people that are working, when they work at Walgreens or Shaw's or any, some of the small shops or any other businesses, they're living at home. They're living with their parents. If I was not extremely fortunate to be in an ADU where they keep the rent reasonable, if I had to go anyplace else and rent anywhere else in Bristol, I couldn't afford it with my store. I wouldn't be able to I wouldn't be able to do it, because I'm looking at how much all the rent is when I look around, and I just happen to find a place that the rent has not gone up and up and up and up and up. So I know, even as a business owner, I could not afford to live anywhere else but where I do in Bristol.
Yeah. I didn't speak to
So,
the affordability of it. I spoke
and-
to there being, I think, enough housing here to support what's happened in Bristol with affordability. It's its juxtaposition to the Burlington area and Middlebury area, where most people work, and we get caught up in the affordability piece, because they don't have the housing in order to have their people be able to live closer to where they work.
Mm.
It's caught up to us down here. Didn't used to be.
so
Okay?
yeah. So,
You
I
know,
mean, you count people living in their parents' home as having enough housing that they might want to live on their own, but they can't afford to because there
well,
aren't enough apartments or.
it's affordability. It's affordability.
Yes, that's what I said.
Ability
It sounded
is-
like you said we didn't have enough. We have enough housing here. We have enough affordable housing here.
We
Is what
have
it
enough
sounded like.
housing to support our workforce and the people that work here. Not necessarily to support the greater county and Burlington area, which we are caught up in. That's all. I
Okay, I don't.
didn't want to make it
yeah.
complicated.
No, I just hear a lot of people coming through and looking, and they'd like to live in Bristol and work here, whether they're self-employed or whatever, and they just talk about the prices of the houses and how they can't afford to do that. So I don't. Yeah, I mean, if you don't want anybody moving to Bristol, then yeah, I guess I guess it's okay. I don't know.
If I can offer a couple quick things. One is there was a really interesting New York Times story. I think it was the Times 2 or possibly 3 weeks ago. Apparently, according to this story, Vermont is the most migrated to state per capita. I'm not exactly sure how they've equalized that, but I read it quickly. It was interesting. Two, as a very small time landlord in downtown Bristol, I can tell you that demand is over the top. And that doesn't comment on the affordability thing, although affordability is partly a function of supply and demand. And when there's short supply, the price goes up.
Sure.
And lastly, I'm concerned both for Bristol and Vermont largely that, and I'm wondering, Kevin and Fred, if you see this, Kevin, more from the legislative point, if the legislature's looking or thinking about this, and Fred, what do you see? But, in states all over the country, the number one buyers of single family homes are hedge funds and other large capital concentrations, and they're buying them up and holding them and renting them back to people. And then, people don't get the equity and they were able to raise the rents. And that's the single largest purchaser of single family homes nationwide. I believe the statistic is investment funds like that. And I don't want that to happen here because that has implications for local control, but also just for having, people far away controlling our fate here in Vermont. So I'm wondering if you see evidence of that, or if that's on the agenda of the legislature or anyone who's focused on housing.
I don't know. One thing I have had a bit of experience with is homes being bought not by hedge funds, but by people who are flush with cash as investment properties and then turned into short-term rentals. I think that's perhaps I just don't know about private equity and those types of things. I think I've seen things similar to that, but I think how much of that is in Vermont, I don't know. I can say anecdotally that none of the real estate transactions I've been involved with, or my firm, as far as I know, have involved that kind of buyer. On the other hand, there are plenty of cases, not so much maybe in Bristol, but other towns, especially towns that are closer to ski areas, where the single family homes get purchased and then turned into short-term rentals by not necessarily out of state, but often out of state buyers who are just buying them up as investment properties. And maybe some of it's single family rentals as well for the same thing.
Fred, you're muted, and we should probably kind of close this up a little bit.
Okay. I agree.
Anything else then, or? I think, we definitely appreciate your talk, and
No problem.
thank you for coming.
Yeah, you're more
Thank
than
you.
welcome. You're more than
Yeah,
welcome.
thank you.
You're welcome. Thanks for listening. Thanks for your questions. I will go home and have dinner. And you guys should do the same.
Thank you.
Talk tomorrow. What time are you in? 9:30?
Yeah,
Later?
yeah, after 1, if you would.
Okay,
I've got consultant in the morning.
all right.
And don't forget your maps.
Yep. I'm gonna get on that one next.
Thank you.
Although that one was old. We were close on the other one because we didn't get the minutes.
So our next item is a discussion point. We wanted to start thinking about what we may consider working on next. I attached to the agenda our implementation action items, I guess you could call it, from the town plan. For those that had a chance to review that, I think. And then we also have some parking lot items that may or may not fold into these items, but I think I'd like to go down through these and whatever level of detail you're interested in looking at them. And kind of give a thought. I don't know if we need to make a decision tonight, but we need to start thinking about where to go next. I took the liberty prior to us looking at the bylaw grant to grouping our implementation tasks into 5 groups, because to me, a lot of them run together or are complementary, even if they don't do the same thing. This group 1 is a group of tasks that are associated with housing and the related needs of living, including business, childcare, circulation, and that sort of thing. So within that group, our tasks have been to identify steps that can be taken to meet the child care needs of Bristol. The blue insets are stuff that regional planning made comments on when they took a look at our town plan for review when through the adoption process. So their comments are also included in this in addition to what we put in. There's one that assess the needs of small to mid-sized commercial and light industrial businesses that are compatible with the character of the town. Maintain and promote the town designation to enhance economic vitality of the downtown area. What's on the next page?
It's this one.
Conduct a housing study to identify housing needs of the Bristol community and review the impact of the short-term rentals on current housing stock. We took care of that within the village planning district, I would say. Continue efforts to make the town and village pedestrian and bicycle friendly and accessible to people with disabilities. That is, so you'll notice on the, some of the assignments are co-assigned. I know the planning commission has, or the select board has established a pedestrian and bike committee that is in some level of operation. Review municipal and standards to ensure that they reflect all complete street principles applicable to our village and rural roads. Again, that's assigned primarily to the select board. Work with adjacent towns, local groups, state agencies, willing landowners to develop low environmental impact biking and hiking trails that promote access to the natural resources area. And that is co-assigned to the Planning Commission and the Conservation Commission at that time. And this bike and walk committee should probably be in on that too. What else?
That's all for group one.
So that's group one. Group two is areas, it has to do with streams and rivers. Maintain adequate stream buffer, bank buffers and existing setbacks that recognize the dynamic nature of New Haven River. Consider the river corridor conservation protection measures to decrease flood erosion losses and increase flood resiliency and discourage additional infrastructure on the river corridor area. Group three has to do with assuring regulation is consistent with a town plan, review all existing zoning to conform zoning changes to the adopted plan, and update unified development regulations to allow a variety of housing types to accommodate all segments of the community. Again, within that group, I think we addressed at least some of that within the village planning area. Group four is a group that has to do with public amenities and the preservation of open land. Identify significant public scenic resources, evaluate opportunities to conserve land with high natural resource value, maintain inventory of significant historic structures, sites, and districts, strive to maintain and improve public access to the New Haven River. And you notice some of those are co-assigned
Man, we often lost our sound. Maybe I'll make you some popcorn.
Sorry about that. We lost power. We're back.
They were back.
Okay. Sorry about that. I lost power on my laptop and just had to deal with that. So, but we're back. Let me bring back the screen share. Oops. We are screen sharing. Okay. Do that. There we go.
So where did we lose it? Was it group 4?
Yes.
Groups, tasks relating to public amenities and preservation of open land. Identify significant public resources, evaluate opportunities to conserve land, maintain inventory of significant historic structures, strive to maintain and improve public access to the Haven River. And you notice some of those are co-assigned, and then group 5 would be things related to energy. Work towards implementing goals and policies of the enhanced energy plan, and work with the Bristol Energy Committee to develop energy projects in Bristol. Those are co-assigned as well. So it's kind of a quick read through, but I'd like to hear thoughts about where we need to go as far as to continue working towards the implementation plan. And we probably should actually, just a reminder, in the parking lot, we have permit notification process, review residential density in RA1, RA2, and RA5 zoning districts, and Airbnbs, or whatever
Short-term rental.
the proper description is, as opposed to using the acronym. So if I'd like to hear thoughts as to where.
Well, I had a question on, I think in group 1, you mentioned the accessibility of downtown, of Main Street. Is that, I think you were referring to that.
Maintain and promote the downtown designation, which is the downtown, to enhance the economic and vitality of the downtown area.
There was something about accessibility. As far as which I took, and maybe I'm thinking wrong, but I took it to mean like complying with the Americans Disability Act kind of thing. Is that
was down lower, I think.
that was
Nick,
lower? It's group 2.
No, it's in group 1. It's second
It's in group
page.
1. Okay.
It's the continued efforts to make the town and village pedestrian and bicycle friendly and accessible to people with disabilities.
Yes. Is that and I don't know if anybody can answer this or knows that, like, accessibility to a building to us, or like there's no accessibility to my store. Is that on my landlord or on the town that it doesn't comply with the Disability Act, Americans with Disability Act?
It's on the landlord, I believe, as a landlord, speaking as a landlord.
Yeah.
It's on the landlord if the landlord does significant renovations that require permitting. Then my understanding, Chris, you might have better knowledge of this, but that they have to essentially try to come up with. Historic buildings get a little bit of a pass.
Because
given their circumstances, but yeah, it does apply.
Because right now I've been told that it's physically impossible to put a ramp to my store, because if to make it usable, it would go out into the sidewalk. It's physically impossible. And I didn't know, is there anything we can address as a town to do something about that? I don't for all the all the shops, all the businesses.
Well, in the renovation that happened on the north side of Main Street, like basically the Shaw's side, the Shaw's parking lot, all of that.
Yeah.
That they did redo the sidewalk, and I believe in all or almost all the buildings that back up there.
In the back, yes.
Yeah,
But they
and-
don't all yeah, they don't all have entrances in the back though.
No,
So,
and not all of them that do have entrances were made compliant, but they really jumped ahead on that really well.
yeah. But
And-
I'm talking about, yeah, on the main street
Yeah. I
on
mean, the
either
problem with ramp,
side. No.
problem with ramps
Yeah.
is that the code is you have to rise no more than 1 inch for every linear.
Right.
foot. So like if you
Right.
got 3 feet to go up, you need 36 feet of ramp.
That's the issue. And I just wonder what other towns, especially historical towns, what are they doing to deal with it? Our main street's pretty wide, so I don't know if there's something that can be done with that, of making it so the street's not quite as wide, but we have some kind of access. I don't know. That's just something that I wondered if that's something we could talk about or study or something. See what we can do.
Mhm. Put that on the list, Kevin.
I'm writing it down, yeah.
Got it.
Actually put it here.
I mean, I've had a dream for a long time that Bristol could be a destination for people with disabilities in our region, if not nationally, if we like went crazy on the accessibility stuff, and I mean, it can be viewed as an economic driver because there aren't many other places for people who are people with disability and mobility issues to go to hang out and be in a small town environment. It could be like an economic thing for us if we really pushed it as much as we could. It could be really neat. I've even thought about, well, is it time to have a lodging facility that caters specifically, but not exclusively, but keeps in mind those needs, those mobility needs and stuff like that, because I know there's a small audience for that, a small customer base, but you could draw them if you made intent that way. I don't know.
Yeah, the easiest way to deal with Main Street is not to deal with the Main Street itself, but deal with the buildings and make the buildings interconnected. So every landlord has to get together and work on interconnectivity. And you use a single point, like on the side, use the existing ramp that is on the side of the Smith McLean Bobcat building. Come in from lower levels that are already there, and then interconnect your buildings from within, not on the exterior.
Oh, come on.
I don't think that would happen.
Can't
because
do that.
fire code and stuff like that would really complicate that.
So,
I
That's
think
not
you
gonna.
have to have separate units, although that's an interesting thought. I know when I did the old auto parts store, what is now Honey Lights, I did have the opportunity, and it was one of my concessions to the state that I would, maximize the accessibility of at least that retail space. And so I put a ramp inside the building. There was enough room to put a 15-foot ramp that didn't really impinge on that large 1,800 square foot space. So I did that interior, and it completed what the town started on the outside by making everything up to that back door of that building accessible. So together that worked well for that one solution.
Why couldn't we have accessibility and one or two points of entry on the outside? Why would it have to be on the inside?
yeah, so.
I mean, but that's getting into details. But anyway, that's just something I think we should be one of the things we talk about pretty soon.
And if you go west a little bit, Virginia's is actually
Yeah,
done a pretty good job with some of that.
yeah.
So we've noted that.
Okay, thank you.
Any other thoughts or comments about what our direction should be next?
Well, this is not a major thing for me, but I like the idea that included on this list is accessibility to the New Haven River. And I think the Bristol Trail Network, as far as it has gone, has proven really popular. Partly the feedback I get from it, having been involved in it, is people love walking along the river down there, in the bottom there, at the bottom of the bank. And so I don't know, that one stands out to me as something that could also be an economic driver and a benefit to the local folks. So that stood out to me as desirable.
So, anybody else How do you all feel about what we've done in the village planning area, to, I guess you could say, improve housing opportunities and, if there's more work to do with that?
I actually had a question. I thought of something and I don't know if this is anything we have anything to do with, but if, say, someone has bought a piece of property, or maybe they bought a property with like an old dilapidated house or something, they tear that down. Is there any incentive the town can offer for them to, if they're building as it, you know, we're talking about investment kind of thing, or they want to build a home just to sell it, to have them build two instead of one large house, build two smaller, as long as they fit within the, you know, within the zoning.
I mean, right now, anyone who has bought property that's subdividable and developable, they're looking at that very hard. They're trying to figure out how to maximize. The
Yeah.
So I just was in talks with somebody who is trying to buy a piece of property and they want to be able to convert it from a single family property into 5 to 6 single family homes. So it's out there.
Okay. So we don't see that problem much. It's kind of the reverse. They want to fit as many.
Yeah, it's sort of the fear that everyone had that we would overdevelop our communities.
Yeah.
It's a catch-22.
Yeah.
That's the question of the RA 1, 5, and 20 or whatever we've got. If you want to eliminate some of those areas so that you can have, 4 units on an acre, which currently RA 1, you would be permitting that more, at least from a town standpoint. And likewise with where you've got to have 5 acres to have a place. And that's one of the things I think that's on your list, right, Kevin?
We have that in the parking lot. So it'd be, and I think we can work that, so we should look at how to work that in, or can work that in, so that we can say that we're working on our tasks as well. That's kind of political, but I think, and why I was asking about if we think we're done with housing impact after doing the village planning area is like it merits probably looking at the rest of the town at some level. That's what you're alluding to, Fred, I think.
I am. We have a very high density residential area now. We've permitted, when you have a single family home, additional units or unit. I think people will gravitate to that in time, especially with households being smaller, big homes like yours. There being flexibility, etc. We want to do it without ruining the character of the village, which is really a nice place. And I see developments like going out what Livingston's did out on the Plank Road, and areas that are close to our higher density residential, so that you can get to Shaw's easily, you can get to the doctor's office easily, but you're not necessarily, going to walk there 3 blocks, and there's more open land, and I think there's opportunities there to have some meaningful housing built. If you have a 3-story, I don't know how many units, Chris, are in the Livingston's place on Plank Road. About.
I want to say there's 8.
Okay. You get a few more like that, and you're increasing the rental spaces, which generally fit affordable housing a lot better than single family homes do. You have more opportunities. So that's my sense of things. Not building things up on Hogback Mountain behind the Bristol Pond, that wouldn't be practical, but close to the village area. It could be very practical.
Okay. John?
Yeah, a couple things, on your question, Kevin, like, as far as like, sort of, have we dealt with density, I think is kind of what you asked. I would hope we would deal with it more, because while we've invited the density, I really don't think that we've given enough, consideration, I guess, to how we make sure that density fits well. I know, as I've said before, I live in the densest part of Bristol. There's no denser place in Bristol than where I live and do my business and where all my buildings are. And I understand what it means to live in a denser place. And as close to a city as we get here, I guess. But and I want density. I want the village to be more dense, more density overall, the whole town. But if we don't address some of these issues that we talk about under the general banner of site plan review, just how people do their lighting, where they put their noise, where they put the building itself on the lot, as we invite density in, then we're going to make density a dirty word, and it will get the density, but it will all be bad, or a lot of it will be bad. I just urge us to look at, I'm not saying we should tear everything down in Bristol and build a new model community, but there are amazing examples of how people have invited density and then make sure it works for everybody who's living closer together then. And I hope we'll look at some of those. So that's one thing. Another thing is, somewhere on the bullet list, let me go back to that. I would like to do that together, like to actually come up with a few examples of what communities are doing in terms of increasing density and making it really livable. And see what we think about that as a group. So that's one thing. I hope that somewhere on the bullet list is, looking at places in Bristol, considering how we can make Bristol more inviting to commercial and light industrial stuff. And that may be, I don't know, I think that's important to consider. I don't know what the answer to that is. It may be finding places where we more, like, maybe there's we already have a C1 district, right? For commercial enterprises, maybe that can be expanded in some way. So we get that kind of stuff where we want it, and also keep it from where we don't want it. So we're not bumping those things up against each other so much. Maybe we create a different zone that is more encouraging. Maybe we expand C1 in some certain ways. I don't know, but there might be ways to look for more deliberate places for those kinds of operations where they're not bumping up against existing residential uses. So maybe we can look at that. That's all I got.
Okay. Slim, have you got any thoughts?
Well, yes, I do. I guess what I've was thinking just then was that I would like to incentivize, and again, I don't know where or anything like this, but the actually much smaller homes. I know there's places that are in the country that are stressed for housing, and there's a lot of 400 square foot homes, 600 square foot homes, and they make big communities out of it. And if we want Bristol to have more light industrial or anything, then I think we have a lot of single people, younger people needing homes, and of course the older folks might want to downsize into a smaller home for coziness and cost. And if that could be incentivized, you could fit a lot of small homes on an acre, and I think it's possible to do it well. If we found the right place for that, I would be definitely a proponent of this, of highly incentivizing very small houses. That's what I got right now.
Okay.
I just want to say that I'm 100% with you on that, Slim. I think it's looking to the future.
Shannon.
Well, I was just noticing the conduct a housing study and identify that. This goes back to, at some point, we were gonna get an intern to help us. I just wonder what happened to that. If that's the only kind of thing that,
Yeah, so with the opportunity we had, I screwed up. And there was a disconnect. There was supposedly a follow-on activity But I haven't seeked out an intern and nobody's been knocking on the door. So I think we would have to put feelers out again for that.
I volunteer.
To be an intern?
Just kidding. Hey, I'm afraid I have to drop off the meeting, but can I just say that I appreciate the open discussion and the sharing of ideas in this context, and it's very helpful.
Okay,
So thank you all.
thanks.
Good night.
Anything else, Shannon?
I see that we talked about, along with the New Haven River access there. And then we talked about Baldwin Creek and obviously Bristol Pond, and I guess my question is there any public besides the one access?
To the
I mean,
pond.
Yeah, because
No.
most of it's all privately owned. I mean, I
Yeah.
could say that because I
You own
own a third of it. I probably own a third of it, and live near. So I just was thinking about that. And the same thing with Baldwin Creek is there's really no way to get to that without
Yeah,
dropping
so
on somebody's personal property, so.
I know BPN has a lot of private property owners that they've worked with and gotten permission, and and I think that has been their ability to do a lot of the trails they've done, because a lot of it's not on public land.
Well, the public land's almost impossible to do, so the feds will not allow them to do anything on their land. Because they want to do a trail on the backside of the river, down along Rockydale, to connect.
Oh, okay, yeah.
To connect, basically come in from the pump house, follow that up through, and then end up at Bartlett's on the backside of Bartlett's. It's all, you're not national forest. Nope, not an option. So. We talk about it, but the feds don't want to play, so. And I have no idea about the state side. They're probably about the same.
They just get locked up in. Fred?
Yeah, just a note. It's good to access our streams and, woodlands and the like. And in my almost 50 years of experience in living here, I've never had a problem getting on them. There are ways, and without being, a poor citizen or trespassing, can always ask someone. The other thing is, the more you access those things, the more you make the New Haven River accessible, the bigger a mess you're going to get. I think public access is important, but I don't know that we want to make, wave the flag too much, because you can create other problems in terms of the quality that the river might have when you have that,
Okay.
as well as other natural resources. It's a catch-22.
Did you have anything else, Shannon?
No, I guess those were the two things that kind of popped out at me. Other than, I see these tasks, do we just take them one at a time, one item at a time, or are we gonna be working, it looks like on almost all of these, the select board's part of it. Do they have a timeline that they're working with?
So some of these, and there is a timeline in the, for each task, quite honestly, a lot of this is aspirational. So I think, we need to keep in mind and work towards them as much as we can, this is my opinion. But we're not gonna do them all, and to be able to affect housing as we have today, and they're still talking about, is significant in of itself, and that just leaves however many other goals that we haven't done, So I don't think it's, like I said, I think it's pretty aspirational. I don't think the town plan was set up. I don't believe the town plan was set up that here's all these things you're gonna do and get them done.
I have a question or suggestion, maybe.
Sure.
If we could take some time with this document, look through it, individually on our own, and come up, if each member can come up with 3 or 4 things that they think we should focus on, and then we get back together and we see if there's a consensus, or what's the most, popular thing that people want to work on, or
Yeah, that's a good point that we've got homework to do, but that's kind of where I think we're at, is we're trying to sort out what our next step is, and
yeah,
so.
I just need more time with it.
That's fine, that's fine. And I had prefaced that, we're not gonna make a decision tonight.
Right.
Likely, so.
Why don't we all come back with some things next month?
So next month we'll be talking about it again.
Yeah. Well, in a more, succinct way, I think, or more
Hopefully.
focused, maybe.
Oh, yeah, hopefully, yes. So Bill, what are your thoughts?
Well, Kevin, I think we always have to be mindful of the importance of creating a growing economy so that the households and families here can enjoy higher incomes and more opportunity. And we also have to figure ways of getting our school population up and our general population up so that we have more taxpayers, not just higher taxes.
Okay, thanks.
Yep.
I think I think Melissa had a good segue, is this will be a good time for us all to just take this stuff and noodle on it, and we'll regroup and figure out where the top 2-3 things that people think we should be working on, and see how those coalesce into some forward activity going forward. Does that make sense? Okay, so on to item 4, continuing business. The select board did have their hearing on the 22nd. And they basically adopted all of the recommendations that we had made, which is going to drive another public hearing. They alluded to doing it after town meeting day, so it would be April, May timeframe. We'll just have to wait and see how they progress on that, and hopefully it doesn't take them longer than a year. Oh, Chris, I forgot this one. There is a document I sent that's the DHCD closeout form. So there is a closeout form that we need to complete for the bylaw modernization grant. And Adam very graciously drafted up most of the verbiage for
This one?
this. Yes.
Hang on, I just gotta share it.
It's included in the handouts, so I won't go over a lot of it. You're welcome to do it at your own leisure. The thing I wanted to bring up and have a discussion about is the last box, which basically is an opinion of how we found the grant, or how the state should be using their resources.
This
And-
one?
Yes, thank you. So this is what I said, and take a quick read at it and see if there's consensus, if it makes sense, if we should change that, or if we should change that. I didn't say a whole lot other than the fact that, essentially we did what we could in the planning area, but our opportunities are just infill and they're limited.
Sounds okay to me.
Looks fine to me, Kevin.
What about everybody else? Anybody want to wordsmith it further, or we just go with it?
I think it's good.
Okay. Okay. Takes care of that one. Now to item 5, administrative matters. We've got minutes to approve for October 17th and January 16th meetings. So we have a motion.
Do you still? Yeah, you do. Okay.
Can I have a motion to approve them, and then if there's any changes or discussion, we can do that.
I'll move their approval, Kevin.
Okay, Bill moves, Shannon seconds. Is there any corrections to be made to them? Hearing none, all those will approve the minutes, say aye or raise your hand.
Aye.
Aye.
Anybody opposed? Any abstentions? Okay. Zoning administrator report.
Just a couple quick notes. As many of you may or may not know, we are hiring a new ZA. I will be done sometime in the near future in my role. We have had an interview, offered the gentleman a assistant zoning administrator role to come in, start working for a couple, 3 months to get his feet wet, find out if this is what he really wants to do or not. And we'll be going from there.
Okay.
What are you doing?
Focusing on clerk treasurer work.
Okay, jumping from the pan into the fire, huh?
You got it.
We have a newly formed committee that Shannon has volunteered to sit on. I don't know if you've had any meetings.
I
on it?
haven't heard from anybody,
Okay,
so I got nothing to report.
okay, thank you. We'll move on to item 6, public comment. Any public comment? Hearing none, we'll move on to item 7. I'll entertain a motion to adjourn. Fred makes a motion and
Slim second.
Slim seconds.
Everyone seconds.
All in favor, say aye.
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 Anybody opposed? Anybody gonna abstain? Okay, thank you very much.
Thank you.
Thank you.
Have a good night.
Thanks. Good night.